if they were to lose the case because of some technical issue in the law of Montana that isn't more broadly applicable, it would be fairly modest. It would be discouraging that they went through all this trial and didn't get anywhere, but that would be, I think, the extent of the damage. If the judge were to say that she didn't believe the climate scientists, that would be terrible. It would be the first court anywhere to have done that, and I don't think that that's likely. I think if the plaintiffs were to lose, it would most likely be on the ground of what's the role of the courts versus the state legislature and the executive in controlling climate change. So it's possible that if the plaintiffs lose, it'll be on that basis, and that would just be the latest of these cases to come out that way.
I'm Tyler McBrien, managing editor of Lawfare, and this is the Lawfare podcast, June 16th, 2023. On Monday, 16 young plaintiffs between the ages of 5 and 22 walked into a packed courtroom in Helena, Montana to sue their government. At issue is a 1972 amendment to the state constitution guaranteeing that, quote, the state and each person shall maintain and improve a clean and healthful environment in Montana for present and future generations. 22-year-old Rikki Held and her co-plaintiffs allege that state officials violated that constitutional right. The case, Held v. Montana, now over a decade in the making, is truly historic, the first ever constitutional climate lawsuit to reach trial in the United States. I sat down with Michael Gerrard, founder and faculty director of the Sabin Center for Climate Change Law at the Columbia Law School, to talk through what's at stake in this landmark case. We discussed the origins of the trial, its potential ripple effects, and where Held v. Montana sits in the landscape of climate change litigation around the world. It's the Lawfare podcast, June 16th. Michael Gerrard on Held v. Montana. So, Michael, you've joined me here today to talk about what many are calling a historic case in terms of climate change litigation, Held v. the state of Montana. If you could, for listeners who may be unfamiliar with the case, could you just set it up for us? What's some of the history of the case, the origin, the plaintiffs, and a bit about what they're demanding?
A group of young people have sued the state of Montana, saying that the Montana state constitution prevents the state from being as friendly to fossil fuels as it has been. The Montana state constitution has an environmental rights provision that was added in 1972 and not used very much since then, but it says that every person has a right to a healthful environment. So Montana has a law that the environmental impact assessment process in the state cannot consider climate change when they are when the state is deciding whether to approve a fossil fuel project. The plaintiffs are saying that is contrary to the state constitution, so they're suing the state.
Yeah, thanks for that overview. And I know there's been a lot of movement even in the past month, but I want to go back to the beginning when the original complaint was filed. Can you walk through a bit of the litigation history to get us to this point today when, at the time of recording, oral arguments are taking place?
So the litigation began several years ago with a broader theory of the state statute. There was a state statute that basically said the state is in favor of fossil fuels. The Powder River Basin, which is the largest source of coal production in the United States, straddles Montana and Wyoming. So a lot of fossil fuel comes out of Montana. After they sued, the state asked the court to dismiss the case on various legal grounds, and the court refused to do that. It said that the case ought to go to trial. Then about a week before the trial, the state went to the state Supreme Court and asked for an emergency order halting the trial, but the state Supreme Court denied that and said the trial should go forward. However, one other thing happened is that the state legislature, in an effort to avoid having to undergo this trial, passed a law repealing their law on the books to be so fossil fuel friendly, which is not to say that they ceased to be friendly to fossil fuels. They just repealed that law and hoped that that would be enough to get rid of the case. But it wasn't. The trial court said, no, we still have this issue under the environmental impact assessment law. So the case is proceeding, although the nature of the relief that the plaintiffs are seeking is more modest than it had been.
Yeah, let's talk about that relief. I think that's one of the most interesting aspects of the case, especially probably for lawfare listeners. Can you speak to what the original relief was that the plaintiffs were seeking, and then how it has shifted into a more modest form, as you just mentioned?
The plaintiffs were originally seeking a court declaration that the statute of the state that said that they favor fossil fuels was unconstitutional. That statute has now been repealed, and so instead the plaintiffs are merely seeking an order from the court that says that the remaining law that climate change cannot be considered in the environmental impact assessment process for considering fossil fuels, that part is unlawful. Now, the environmental impact assessment laws are only assessment and disclosure. They're not substantive. And so the state could consider climate change as part of the assessment process, but still go ahead and approve a fossil fuel project. So the immediate legal effect of a victory for the plaintiffs, if that's what we see, would be very limited, but the decision would have considerably broader significance.
Yeah, and I definitely want to get into some of those ripple effects and, what sort of other litigation that such a victory could unlock. But first, I want to take the sides each in turn. So as you mentioned, the plaintiffs are a group of young people, some quite young. So I wonder if you could just speak to a bit about the unusualness or not of such a young group of plaintiffs. And then more on that side, what are the plaintiffs having to prove here, especially in terms of perhaps climate science, things of that nature. So again, just on the plaintiff's side, who are they, and then what hurdles are they facing right now in the case?
So let me back up again. So there's an old theory that actually goes back to the Justinian Code called the public trust doctrine, with the idea that the government has an obligation to protect aspects of the natural environment like forests and lakes and rivers. A professor at the University of Oregon, Mary Wood, wrote a number of papers saying that the public trust doctrine should also apply to the atmosphere and means that the government has an obligation to prevent dangerous climate change. A nonprofit group then formed in Oregon called Our Children's Trust, which began bringing lawsuits around the country using this theory. Most of the cases were dismissed fairly quickly. One of them became very prominent, called Juliana versus the United States. That was dismissed. It may come back to life. That's a different issue. But the plaintiffs in Oregon were following this pattern. All these cases organized by Our Children's Trust, where you have a group of young people who are the named plaintiffs bringing these lawsuits to highlight that the worst effects of climate change are yet to come and will affect these young people later on in their lives and future generations. So in the trial, these young people are testifying and are talking about how climate change is affecting their own personal environment. One of them likes to do rafting, another is a hunter. Others engage in outdoor sports and so forth, and they have all been testifying about how climate change is making all of those activities much more difficult for them. So their principal argument, as I said, is that the state constitution requires the state to take actions to protect them from climate change. It's narrower now just on environmental impact assessment, but that is their fundamental claim.
Now, let's turn to the defense. What have state officials been saying their defense is going to be? What have you read? What is their response essentially to the complaint and the lawsuit?
So they're not denying that climate change is happening or that human activity played an important role in it. They are saying that it's not so bad. They're bringing forth a witness who is saying that climate change, it's happening, but it's not as catastrophic as the plaintiffs say. And more importantly, they're saying that the contribution of Montana to greenhouse gas emissions is so tiny that it wouldn't make any difference even if Montana stopped all of its emissions, that the emissions that are causing climate change resulted from the activities of millions of people over a century, and so it makes no sense just to pick on Montana.
Yeah, I think one of your colleagues wrote a piece about this sort of defense which maybe he or someone else coined as a sort of drop in a bucket defense. How have courts ruled on similar defenses in perhaps similar cases?
So the same argument was raised in the landmark U.S. Supreme Court case of Massachusetts versus EPA in 2007. The defendants, EPA under George W. Bush, were saying that it didn't make sense for them to have to control greenhouse gases because of all the emissions from China and so forth. But the Supreme Court majority said no, every country has its own obligation and every country needs to do its part. And so exactly the same thing is coming up here, that even though it's true that Montana's emissions are a small part of the global picture, every place, every unit of government, every company needs to do its part.
And now to turn back to the question we were addressing earlier, what will change if the plaintiffs are victorious here? What are some of those ripple effects that you mentioned? What sort of litigation could this unlock, as I asked earlier?
So this is only the second trial on climate science that's ever happened in the U.S. In fact, in the world. There was one in 1997 in Vermont, but this is the only one since then. There have been a lot of decisions based on submissions of papers and arguments of lawyers, but this is only the second time that you've had live witnesses on the stand subject to cross-examination, subject to the crucible of a trial. If this case is successful, I think it will send a message around the world that climate science has withstood this kind of examination, that if the court rules in favor of the plaintiffs, that this court, after hearing evidence on both sides, has concluded that it's a serious issue. And I think it could embolden other lawsuits under a variety of theories. We saw something like that happen a few years ago. There was a very important decision in the Netherlands called the Urgenda versus Kingdom of the Netherlands case, where the courts of the Netherlands held that the government of the country was doing too little to reduce the country's greenhouse gas emissions and gave the country's government very specific numerical targets for reducing their greenhouse gas emissions. That decision helped spark a wave of decision in several other countries around the world. And we now have successful lawsuits in Germany, France, Mexico, Colombia, Nepal, several other countries under comparable kinds of theories. So a success in one place tends to engender similar kind of cases in lots of other places.
That's really interesting. I mean, on the one hand, it does make sense given the interconnected nature of the climate crisis. I'm curious if you can pick a few of those examples to sort of follow the thread. What happened after these successful lawsuits?
So in the Netherlands, the government did tighten its targets, and it closed a number of coal-fired power plants earlier than it had planned to do. Now, that is not to say that they're doing enough. And in fact, a few months ago, a citizen group brought a new lawsuit in the Netherlands saying the government still isn't fully complying with this order. In France, a court told the government of France that it needed to do more to reduce its greenhouse gas emissions. The government did some, but just about 2 months ago, a different court in France said that the government of France still isn't doing enough. So these decisions don't necessarily have an immediate impact. It's not like the many lawsuits that say you can't build this pipeline or you can't build this power plant. Those do have an immediate impact. These cases that are looking more generally at a country's emissions require continued watchdogging and enforcement to make sure that the requirements are met.
Now let's talk about the flip side. What do you see potentially happening should the plaintiffs lose their case?
Well, it would partly be a question of on what basis do they lose the case. If they were to lose the case because of some technical issue in the law of Montana that isn't more broadly applicable, it would be fairly modest. It'd be discouraging that they went through all this trial and didn't get anywhere, but that would be, I think, the extent of the damage. If the judge were to say that she didn't believe the climate scientists, that would be terrible. It would be the first court anywhere to have done that, and I don't think that that's likely. I think if the if the plaintiffs were to lose, it would most likely be on the ground of what's the role of the courts versus the state legislature and the executive in controlling climate change. Many cases that have been brought around the world have been dismissed on that kind of theory. So it's possible that if the plaintiffs lose, it'll be on that basis, and that would just be the latest of these cases to come out that way. So I think that would have some but limited negative impact.
And speaking of the role of the courts in addressing the climate change, I'm curious, why this is so historic, essentially. Why is this the second time that climate science has gone to trial? What explains, in your view, reticence on the side of the court to take up cases like this?
Well, most of the cases, the great majority of the cases that have been brought under climate change, and let me just say that the Sabin Center for Climate Change Law maintains a database that tries to capture all the climate litigation in the world, and we've found about 2,200 cases around the world, of which about 70% are in the U.S. But the great bulk of these are brought under administrative law theories, where the courts are merely looking at the administrative record. And so the decisions don't go to trial. The courts looked at whether the administrative record supports the decision that was made by the agency. This is one of the very few cases that is brought under a constitutional theory, and that's how it has gotten to the point where a trial was necessary. So procedurally, it's unusual. Our Children's Trust, as I said, did bring a bunch of lawsuits under comparable theories, but all of the others were basically dismissed, mostly because of separation of powers concerns and related kinds of considerations.
And do you have a sense of how many other states have a similar Green Amendment or a similar environmental protection enshrined in their state constitution?
It's about half a dozen. It's a question of how you define it, but Pennsylvania has one, and that became the subject of an important decision from the Pennsylvania Supreme Court about a decade ago concerning fracking. Hawaii has one, and that's the subject of a trial that's coming up in September concerning the force of Hawaii's environmental constitutional right. New York adopted one just about a year and a half ago. New York now has a new constitutional right to a clean environment embedded in its state constitution. And there have been a handful of lawsuits brought under that, but none of them are really about climate change.
And given that this is playing out at the state level, do you see the federal government getting involved in any way? How could this interact with federal policy or the federal government, if at all?
Well, the federal government is not at all involved in this lawsuit, and in general these days, environmental plaintiffs are less eager to go to the federal courts for this kind of relief because the current U.S. Supreme Court is not a very friendly venue for establishing new rights. It used to be that the Supreme Court was establishing or declaring new rights, but in more recent years, they have been taking away rights. So the plaintiffs in these kinds of cases are less likely to want to go to federal court than they are to go to state court.
Now, turning back to the case itself and the trial, rather, what is the current status of the trial, and what are you looking out for as oral argument unfolds over this week and the next?
Yeah, so it's not just oral argument; it's a live trial with witnesses, and it began on Monday. Today is Wednesday, the 14th. It's going to go on a total of 2 weeks, and so what's been happening each day so far is that the plaintiffs have put on a couple of expert witnesses, and have also put on several of the young plaintiffs. The state has chosen not to cross-examine the young plaintiffs, and they've asked some questions of the live witnesses. So the case is scheduled to go, as I say, a total of 2 weeks, and then presumably there will be some post-trial briefs, and we'll wait for the court to decide.
And it may be obvious to some, but can you run through the legal strategy there of why the state has chosen not to cross-examine these young plaintiffs?
Well, these young plaintiffs are sympathetic people. And I think that if the state were to cross-examine them, if they were to go after them, they would just come off as mean, and they didn't want to do that. In the Giuliani case, there were depositions of the young people. And for instance, the young people were were pressed on things like, you say that your asthma is worsened. Do you have measurements of the degree of coughing and the degree of air pollution and so forth? It just comes off as mean to go after these young kids. So I think it's a wise tactical move by the state not to cross-examine them.
Now, there have been a lot of superlatives thrown around in the coverage leading up to the trial and of the trial itself. What's your sense of just how big a deal Held v. State of Montana is in the greater landscape of climate litigation? You mentioned that the center maintains a tracker, a global tracker. How big a deal is Held situated, in the backdrop of these 2,200 other cases?
Well, for years, the plaintiffs and environmental advocates have been wanting a trial, or wanting several trials, wanting to actually put witnesses on the stand and hear from them and let the other side cross-examine them. Except for this one case in Vermont in 2007, this is the first time that has happened. So, and so much new science, climate science, has come out since then. It's quite something to watch, and it's being streamed on Zoom, to watch actual scientists giving this testimony on the witness stand. That hasn't happened before, with that one Vermont exception.
I'm curious also what the risk is here for anyone who wants perhaps the state to do more to address climate change or to curb fossil fuel industries' pollution. Is there any risk here in pursuing these types of lawsuits besides the obvious risk of the potential to lose it? I guess are there the drawbacks to this sort of legal strategy?
You have to look at each case, but I think that the drawbacks are very minor, because the odds are quite low that the court is going to find that climate science is a myth, or that kind of thing. Any judge that had that view probably wouldn't let the case get this far. So I don't think we have that risk. Clearly, if the plaintiffs lose, the opponents of climate action will make a big thing of it. But I think that the legal grounds for under which they might lose are pretty narrow and wouldn't have much negative impact.
And as you continue to watch the trial unfold on Zoom, as you mentioned, or as you read, the post-trial briefs and other things, what are you specifically looking for as more information comes out and as the court rules on aspects of the case?
Well, I'm going to be interested to see what the state's witnesses say. They know that they're putting on a well-known climate scientist named Judith Curry, who is not a climate denier by any means, but she tends to say that climate change isn't as bad as many of the environmental advocates say that it is. I'm sure she may also say that the contribution of the state of Montana is so minor that the court shouldn't order action. But we don't know exactly what she and the other state witnesses are going to say. And so I'm eager to see how that goes and to see what happens in cross-examination.
One thing I always like to do is to open it up to the guest. Is that, is there anything else that you want to speak about in terms of this trial or similar ones? Anything I should have asked you that you wish I did? Anything else really?
Well, a couple of things. One, I've noticed that all of the expert witnesses that the plaintiffs are calling are experts from Montana. They're climate scientists and physicians and others from Montana who are all superbly qualified. And I think it was an excellent tactic that they chose to choose people from within the state and not to fly in people from distant areas. Another thing I'd like to point out is that the last 4 or 5 years have really seen globally quite a remarkable trend for more climate change litigation and more victories in climate change litigation. As I said, that we've seen decisions in quite a few countries where the courts, mostly using constitutional theories and human rights theories, have told governments that they need to do more to fight climate change. There are also climate change cases that are now pending before the International Court of Justice in The Hague, before the Inter-American Court of Human Rights in San Jose, Costa Rica, before the European Court of Human Rights in Strasbourg. One has been brought before the International Tribunal on the Law of the Sea. One is expected shortly before the African Court of Human and People's Rights. So this litigation is really becoming very prominent, very active all over the world, largely because few, if any, governments in the world are taking adequate action to fight climate change. Ideally, the governments would act and the national parliaments would act, but failing that, people resort to the courts, and quite a few of the courts have become very receptive to this kind of claim.
Just to go back briefly on your first point, I'm curious why you think that's such a good strategy to have specifically Montanans testify at a Montana trial.
Well, it's easy for a state court or people in the state to say, oh, these are people parachuting in from New York or California and whatever. What do they know about our state? And I think it's much more persuasive if you have people from the state who know about the particular conditions in the state and can speak more authentically to the issues they're addressing about the impacts that climate change is having on the state.
And in the many other cases, both domestically and internationally, that you just mentioned a second ago, what's the one or two that you're really following closely in the coming months and years?
Well, there are a couple where the decisions are eagerly awaited. A trial level court in the Netherlands ruled in a case against Royal Dutch Shell that the company needed to reduce its greenhouse gas emissions, and not only those in the Netherlands, but also globally, and not only the emissions from the operations of the oil company, like leakage, but also the emissions from its customers, the people who use the gasoline and other fuel that Shell produces. So that was quite a remarkable trial-level decision. It's now under appeal in the Netherlands, and people all around the world are watching eagerly to see how the appeals come out. Another case where we're awaiting the decision is a farmer in Peru, Mr. Lua, is saying that his farm is endangered by the melting of the glaciers in the Andes. And he's gone to a court in Germany saying that RWE, which is the largest electric utility in Germany, is responsible for 0.5% of global greenhouse gas emissions, and therefore RWE should pay him 0.5% of his damages. Obviously, this is a case brought to make a principle rather than to get a lot of money. The total amount of money has been calculated at about $20,000. But the trial court in Germany allowed the case to go forward. They threw out the motions to dismiss. They indicated that they actually wanted to go to Peru to see the glaciers. The pandemic then happened, and that delayed them. But a couple of months ago, they actually did. Several of the judges went to Peru. They looked at the glaciers, which certainly suggests that they're very interested in the case, since that's quite an extraordinary step for judges to do. And we're now eagerly awaiting the decision from that German court to see how that turns out.
Well, Michael, I'm not sure how you do it, keeping such close track of litigation in Montana, in South America, in Europe, but we are very glad you do, and I really appreciate you taking the time to come and speak with me on the Lawfare podcast.
Good talking to you.
The Lawfare podcast is produced in cooperation with the Brookings Institution. You can get ad-free versions of this and other Lawfare podcasts by becoming a Lawfare material supporter at patreon.com/lawfare. You'll also get access to special events and other content available only to our supporters. Please rate and review us wherever you get your podcasts. Look out for other shows, including Rational Security, Chatter, Allies, and The Aftermath, our latest Lawfare Presents podcast series on the government's response to January 6th. Check out our written work at lawfareblog.com. The podcast is edited by Jen Patia-Howell, and your audio engineer this episode was Noam Osband of Goat Rodeo. Our music is performed by Sophia Yan. As always, thanks for listening.